is now in session.
Thank you. Please be seated. Good morning. This is a time set for oral argument in our case number CV15-0439, Best of Europe Adult Home Care LLC versus Arizona Department of Health Services. We're delighted today to be joined by Mark Moran, presiding judge of the Coconino County Superior Court, who's serving as a judge pro tem with us. Thank you, Judge Moran, for your service. Counsel, each side is allocated 20 minutes for argument. The appellant may reserve a portion of that time if you wish to do so. If you wish to do so, you need to keep track of the time using the podium clock. We will not be doing that. Out of respect for counsel, I would ask those in attendance to make sure that your cell phones are off so counsel's argument is not interrupted. We have read the briefs. We've conferenced the case this morning. We'd encourage you to keep that in mind as you present oral argument that we are familiar with this record. Proceedings are being recorded and will be posted to YouTube. So as you begin your argument, please, if you would, state your name and the party that you represent. With that, let's start with Mr. Connolly.
Thank you, Your Honor. Good morning. May it please the Court. John Conley on behalf of Best of Europe. This case is about due process and the ability of a licensee to seek judicial review of a government agency's action affecting its legal status. It is also about whether an agency can insulate itself from judicial review by labeling its final administrative determination that a licensee committed serious violations of state law as a non-disciplinary action, and by dropping a proposed monetary fine after a licensee indicates that it plans to challenge the agency's determination in an administrative hearing. This Court should reverse the Superior Court's summary order granting the Department's motion to dismiss for two main reasons. First, because the Department's statement of deficiencies is a final administrative decision that affects the facility's legal rights and obligations, it is subject to judicial review under the Administrative Review Act. Second, because the SOD both impacted the facility's reputation and altered its legal status, the Department's action affected the facility's liberty and property rights and triggered due process protections. The denial of any type of hearing by the Department violated the facility's due process rights under Arizona and United States constitutions.
Counsel, I want to hear from you a fair amount on your statutory argument why this is a final administrative decision, but let me ask you to address briefly your argument that anything that might arguably implicate a due process or a liberty interest automatically is appealable to the court.
I think that the Supreme Court in the Fox decision, Your Honor, addressed that quite squarely.
Well, help me understand that, because that had, as I read Fox, it didn't really have to do with the Federal Administrative Procedure Act at all.
Well, one of the arguments set forth by the government in Fox was that the litigant should not have been in court in the first place because there was no subject matter jurisdiction. There had been no due process violation. That gets kind of buried in that decision.
It may get so buried that I couldn't see that. So help me better understand that argument.
Sure. In the Fox decision, the government, the FCC, argued that there was no violation of, that there was no penalty, really, to Fox because the government had decided it was not going to take any disciplinary action against it, which is exactly what happened here. The government said initially we're going to fine you $500. We showed them that they were going to lose an administrative hearing, and the government said, well, we'll take it back. We're not going to fine you the $500, but we're still going to find that you violated the law. Well, you know, for my client, just as Fox and ABC in that case, the government's determination that there was a violation of the law, plus the fact that that violation could be, and in this case must be, considered in future proceedings and could result in increased penalties, results in a sufficient infringement on their rights to warrant some sort of due process. And in this case,
Help me out, though, and then I want me to be quiet and you to turn back to your statutory argument, which I do want to hear more about. But if what's the bound if Fox says anytime a party, if Fox stands for the proposition that anytime a party alleges that there may have been some either due process violation or action that would implicate their due process rights, that you can go straight to court. When would that never be the case? When would the trial court never have jurisdiction? I mean, the Administrative Procedure Act seems very constrained for a lot of reasons, policy reasons, when you can go to court and when you cannot. And the due process argument that you attribute to Fox would seem to sort of completely end run that.
I don't think so, Your Honor. I think the due process in Fox is consistent with the court's previous opinion, Paul v. Davis, which is if you have stigma plus, so that would be the dividing line. Is there stigma plus? Is the government action going to create a stigma for this entity or individual plus something else? And in this case, that something else is the mandate that the department look back at these at the SODs and take that into consideration when issuing future penalties, just as that was the case in FCC v. Fox. And even in Fox, as I stated, the FCC said, well, we're not going to, don't worry about it, we're not going to take any action. We're not going to look back and take this into consideration. And the court in that case said, well, the government's largesse is not sufficient. If there is, as in Paul, stigma plus, that is the dividing line. And that's what separates this case from Murphy, which is, frankly, what we're probably here to talk about. Because Murphy has been the dividing line for quite some time, and Murphy, I believe, is distinguishable from this case. So I think the court can rule in favor of my client without having to overturn Murphy. But to the extent the court does believe that Murphy is controlling in this case, I think that Fox has set us on a different course, and I think that Fox would mandate that this court overrule Murphy. Because in Murphy, what we had to separate it from our case was an advisory letter of concern with really no mandate that any more be done. There was we suggest or we believe that Dr. Murphy should do this or that, but there was no mandate really in that case, and it was simply an advisory letter of concern. And this court determined that does not warrant an appeal to the Superior Court.
But wouldn't you be making a similar due process argument, because Murphy specifically allowed the medical board to use that against him if there were future disciplinary proceedings? So wouldn't you be making the same due process argument?
I would, Your Honor, and I think that that's where we are. I think that Fox has if we believe that Murphy is controlling, I think that Fox requires this court to apply the precedent set in Fox and overrule Murphy.
What progeny from Fox best supports that argument?
Well, I think as I've discussed, Your Honor, Paul v. Davis was one of the cases that the Fox court relied upon in their decision.
And I understand
that was a
that.
liberty.
My question's a little different than that. Fox has been out there for 2 or 3 years, and if in fact it creates the jurisdiction or establishes or recognizes the jurisdiction that you're advocating, my thought would be that there would be many cases applying Fox.
My apologies, Your Honor, and when you said progeny, it didn't register initially. Frankly, Your Honor, at this point, I am not aware, not possibly because there isn't something out there somewhere, but I am just not aware of it. And perhaps, as the court has stated, there is a bit of an issue with Fox in that a cursory look at it leads one to believe that it is solely about whether or not a rule was void for vagueness or a statute was void for vagueness. But when you delve into that case, There's two holdings in that case. And the second holding is the one that's important here. And not only is that holding obviously relevant to this matter, that holding relies upon the Paul decision. And the Paul decision was a liberty interest decision, just as this is, we would consider it a liberty interest decision, although it doesn't really matter whether you address the case at hand as a liberty or property interest. What matters for the purposes of this argument is that, as in Fox, there's always a two-step approach when you're talking about these constitutional due process issues. Fox, of course, in the court's opinion, focuses substantially on the second issue, which is what was the violation, or whether a violation had occurred. But the first issue is always, is there an interest? Is there an interest to be protected? And in the Fox decision, somewhat sandwiched in between the other argument, it expressly states that, yes, there was an interest to be protected. And that interest is to be protected when there is stigma plus something more. And that something more, as in Fox, and in this case, is the fact that the agency must, in this case, must rely on or look back at these SODs when
No, my question, I
further
think
review.
you've answered it, but I want to make sure we're on the same page, is Fox was decided in 2012, and if it, in fact, it stands for the proposition that a party who claims to be aggrieved in the way that your client claims to be aggrieved can effectively cut beyond or go to court quite apart from whether there's a final agency action under an Administrative Procedure Act, be it federal or state.
Mm-hmm.
I would think that there'd be cases applying it in that context in the intervening 4 years. And I haven't located any. And it sounds like, if I hear you right, that you, as you stand here today, are not aware of any either.
That is correct, Your Honor.
Thank you.
So let me back up just a bit, and I'd like to save 5 minutes, so I'll try to work through this as quickly as possible. With respect to the statutory argument, as the Court knows, the statute says that an agency decision is judicially reviewable if it affects legal rights, duties, or privileges of persons and terminates the proceedings before the administrative agency. And in this case, as I had mentioned, the legal rights, duties, and privileges of this agency are clearly affected. First, there is a stigma to having these deficiencies posted on the website. And second, as in Fox, these deficiencies must be considered going forward. One of the arguments that the agency has set forth in this case is that, well, we decided to pull back our decision to find this entity, and we're just continuing to monitor it, so therefore there's no finality. But that argument was squarely rejected in the Supreme Court's decision in Sackett when the EPA case, where Justice Scalia said simply because the agency decides it's not going to take any action or is going to continue the matter going forward does not necessarily mean that this isn't a final decision. If it has all of the indicia of a final agency decision, they've applied the law, the facts to the law, they've, in our case, determined that there were violations, they've mandated that my client do something, correct those deficiencies, and then at the end of the day went back and re-inspected and sort of oddly said that the deficiencies had been corrected when our argument has always been there are no deficiencies and we really didn't do anything. I mean, there's clearly finality in this case. And finally, Your Honor, before I run out of time here, separate and apart from these issues is the issue that the Superior Court does have independent subject matter jurisdiction, because this action by the agency has created this sort of constitutional no man's land for my client. It's the agency's decision that we're just going to stop the enforcement proceedings and pull back the $500, well, not stop the enforcement proceedings, but pull back the $500 fine, which would have clearly triggered my client's right to an administrative hearing, leaves my client with no redress other than the court. You know, the agency will say, well, you can't get to court because you haven't exhausted your administrative remedies, but you haven't given us any administrative remedies to exhaust. You've pulled the rug out from under us when you withdrew that fine. And simply because you want to describe your SOD, Statement of Deficiency, as something other than an adverse action does not mean that it's not an adverse action. Again, we keep going back to this, but there's stigma plus in this case, so it clearly is an adverse action. So without the ability for the Superior Court to look at this case on a purely constitutional due process basis, is this entity entitled to its day in court somewhere? We're left in this no man's land, similar to what happened in the Sackett case with the EPA, where Justice Scalia, I believe it was the Sackett case that, no, I apologize, it was the Bolser case that this court decided, where it stated that, the registrar contractor's decision to say, well, we're not going to give you a hearing creates this absurd result where the agency gets to decide whether or not you ever get to court by denying you due process in the first place. And obviously this court has rejected that once. It should reject it here again. Thank you.
Thank you. Ms. Lamanga?
Lamanya.
Thank you.
Thank you, Your Honor. Good morning. May it please the Court. Patricia Lamanya, here representing the Arizona Department of Health Services. The only issue really before this Court is that the Statement of Deficiencies issued by the agency is not a final administrative decision because it did not affect the rights, duties, and privileges of appellant and terminate any proceeding that may have been before the agency, which, of course, is required under 12-901, Section 2. Therefore, the Superior Court lacked any jurisdiction to hear an appeal lacking the finality. This Court's decision in Murphy held that a regulatory action agency or board can take a non-disciplinary action, and just because it's recorded and made public doesn't affect the legal rights, privileges, and duties of the licensee. In this particular instance, the Statement of Deficiencies has not affected their legal rights, duties, and privileges. They are acting under an active license. They have been since 2004. It has been renewed every year. Without those legal effects, they cannot now claim that it's final and reviewable by the Superior Court, which is indeed why it was dismissed. And just as in Murphy, the appellant here has claimed a reputational injury. And this court found in Murphy that that was speculative, that just claiming that your reputation had been harmed is not enough. And that's based primarily for appellants on the fact that this SOD is a public document. But in fact, the nature of this document being public is a legislative action. ARS 36404, along with the statutes in Arizona about public records, indicate that the Department of Health Services must make these documents available to the public, with some exceptions about privacy issues. So the fact that it's public alone does not directly affect the reputation of this particular facility.
So let me ask you one clarifying and one hypothetical question. The clarifying question is that from the agency's perspective, the SOD is not a disciplinary action, is not discipline against the appellant's license. Is that what I hear you saying?
That's correct.
And then you indicated, if I heard you right, that the SOD is a public document because the legislature says it needs to be. And because of that, that could not cause any reputational harm that would be cognizable. Wouldn't that depend on what the SOD said?
Well, it could, yes, Your Honor, but in and of itself, the fact that it's public doesn't directly affect the reputation, because if that were true, then any of the more than 10,000 licenses that exist under the Department of Health Services who had been issued a statement of deficiencies could claim reputational injury.
And let me ask you then the hypo that follows. And what if the SOD, and this is not what the SOD said with respect to appellant, so this is purely hypothetical, has a conclusion that says no one who cares about anyone should place a family member in facility X. And then that, if it were up to the agency, would be kept internally, but because the legislature says an SOD has to be published, that's published. Would your argument be that there's no reputational harm there, that that there's no injury to the residential facility? That's not what this SOD said, not
Correct. Anywhere
close. And so I
Correct.
want to make clear to everyone that's a hypothetical. But I think it's more than just that the legislature says the SOD has to be published.
Well, in your hypothetical, which I imagine wouldn't happen specifically by my agency, but
I'd be surprised if it did.
yes, but if language in your hypothetical were used in a statement of deficiencies, and then that by it being public and someone using that language to affect injury on a licensee, for example, choose specifically not to refer people to that facility, that's a cognizable injury. Certainly, it would fall under reputational injury, but reputational injury is speculative in and of itself because there is no attending action that affects the licensee's ability to run its facility in this particular case. So I hope that answers your question.
Well, it does, although it begins to merge the hypo
Yes.
into this case, and it was intended to be an extreme example, but I think you've addressed my concern.
As to the arguments that appellant has made about the Fox case, I agree with the questioning that Your Honor, the line of questioning that Your Honor was asking to appellant, that they're really the consistent and primary holding in Fox really is based upon the lack of notice and the vagueness of the policy that was directed by the FCC against Fox in particular, almost a year after the actual fleeting expletive was uttered during a show in that time period. It wasn't supposed to be before midnight. And their primary concern in that case was that the unfairness of that and the due process violation. And in fact, the language of Fox even indicates that the discussion about stigma plus, the reputational injury plus, being able to, the FCC being able to use the violation later on, that those were not enough to cure the constitutional violation. And that's the language of the case, at least in my memory right now. But so that language indicates, in my reading of that case, that without that initial constitutional violation, without the notice and the vagueness issues, they wouldn't have reached that secondary statement about reputation and the fact that it could be used, and really seemingly a reaction to the FCC's backpedaling in this case. In that case, in this matter, appellant has characterized the actions of the department in a way that do not reflect the record, do not reflect what occurred. Although the record here is not enlarged because there was, no hearing and available to appellants, but the decision made to not go forward with the civil money penalties was not based on the fact that the department believed it was incorrect in the violations that it found. The department did go back and make a decision that the difference between enforcement and keeping those violations on the SOD was important based on the information they'd gotten from the facility. But the fact is that there was, in their judgment, and this was done by an enforcement team that reviews these violations, those two violations about the fact that this particular residence care plan was never updated were not addressed properly. And they were not enough to say, well, that didn't occur. And the fact that that care plan did not reflect the direct care that she should have been and perhaps was receiving didn't attend to those needs. So those things were not addressed in the information that the appellant gave to the department. And that was a decision that they made. It wasn't about them being incorrect. The department, on a daily basis, will remove things from statements of deficiencies if they believe that they were wrong. And in fact, that occurs on a daily basis. So I wanted to just correct that today. And your questions about the progeny of Fox, as early as this morning, I was making sure that there were no cases that cited to Fox for that proposition, the proposition that appellant relies upon here regarding reputation and stigma and ability to use a violation later on. I looked at every case, every state and federal case that cited Fox, and none of them addressed that issue. All of them were about vagueness and notice as a tenet to due process rights. The other points I wanted to make.
Yes, let me ask you, could a SOD, and again I'll ask you a hypothetical, from your perspective, ever be a final agency action that would be appealable under 12901?
No, the department would issue an order, and that order from the director indicates finality and therefore triggers the Title 41 Administrative Procedures Act. And in fact, there are several statutes that discuss things that the director can order one of the licensees to do. It's ARS 36-428, talks about hearings in front of the director and lists a whole variety of things that the director can order a facility to do. And in those cases, those are all final orders. And then those, of course, become appealable and trigger hearing rights in those particular matters. Again, because those things do affect, unlike this situation, affect the licensee's rights. And I also wanted to lastly address the issue about independent, as appellant states, independent jurisdiction over the constitutional argument here. In this particular matter, appellants the appellants approached this by using the Administrative Review Act and filing their action on January 9th with Superior Court. They didn't ask for an administrative hearing from the Department of Health Services until January 16th. So they triggered their appellate rights when they hadn't been officially or denied those rights by the agency. So I wanted to just...
Chronologically, you're right, as I recall the record. Yes. But where does that take us? Because I think the agency's response was there's nothing to see here, there is no final action, and there may never be any final action. So I'm not sure where the chronology takes us.
Well, it goes directly to the argument about why we raised the issue of exhaustion of administrative remedies, because if the court decides that there is finality in this decision, then we believe it belongs back with the agency, and then that a record can be made and the agency can look at it from that perspective. The reason that we raise it also is because of the jurisdictional question. So Mr. Connolly expressed this idea that there's a due process or a constitutional dead zone. I don't know if that's the language you use, but
no man's land.
Thank you, thank you, Judge. No man's land, and if that is indeed true, they should have sought and they should have asked officially for that administrative hearing based on what they believe to be a final decision of the December 3rd Statement of Deficiencies before they sought Superior Court jurisdiction under the Administrative Review Act.
On that point, Ms. Lamagna, could the healthcare provider, once the civil penalty was assessed, the $400 penalty, whatever you want to call it, once it had been assessed for 4 months, nothing happened, if Best Care had actually asked for the administrative hearing based upon the fine, would they have been granted that, in your opinion?
Well, it really, Your Honor, it would really depend upon if the agency had issued a final order. The reason the agency hadn't issued a final order during that time period is reflected in the fact that the agency was still receiving information from the entity. But the normal process would be that they would assess the civil penalty, a legal order would be issued by the director, and that would be appealable. I can't speak to the fact that whether or not they had actually asked at that point whether they would have been given a hearing or an order would have been issued. It's difficult for me to go back and speculate on that, but that's the normal process that they would have gone through for that particular issue.
Okay, thank you.
Mm-hmm. So as far as the jurisdictional argument, I just wanted to kind of touch back on that. Appellant spends a lot of time talking about this independent jurisdiction, but here, the way that the constitutional arguments are raised, they're contingent upon the finality of the decision or the lack of the finality of the decision affecting the due process rights. And this action was brought under the Administrative Review Act. It was brought under ARS 12904, which means that is under the legislature's tutelage, that is the exclusive jurisdiction of Superior Court to review those administrative decisions. So there was not an independent constitutional violation brought before Superior Court, and that is also reflected in the dismissal here. If the court has no other questions for me?
I have another question, Ms.
Okay.
Lamagna. You did quote the requirement under the statute that the agency publish the results of any SOD, and I took note of that. If someone actually complies with, to the satisfaction of the agency, cleans up the SOD issues, is that also made public?
It is. If they issue
Compliance?
yes, the compliance is also made public, and the public file for any licensed entity under the department has all that information. Of course, excluding privacy information that is deleted from those files, but that would be made public as well. The entire history, and they keep the documents for a 3-year period, so a 3-year history of any of the licensed entities are available on a public records request. So.
Thank you.
Thank you, Ms.
Okay, thank you. I just wanted to, again, thank you very much for your time today, and again, request that you affirm the decision of the Superior Court. Thank you very much.
Thank you. Mr. Conley, rebuttal.
Thank you, Your Honor. Just to put a bit of a finer point on our previous discussion regarding what is the dividing line if we follow Fox. Again, reputational injury alone is not sufficient, but where there is, and I'll use the language in Fox, alteration of legal status, that is the dividing line. An alteration of legal status is when an entity, such as my client, can be subject to greater penalties in the future because of a determination like the SOD in this case, or finding that that there was a broadcast of improper materials in Fox. That clearly dovetails into the language in our statute, which we're here to talk about today, which discusses the right to a hearing when legal rights are affected. Another way to say that is when there's an alteration of legal status. So you can clearly take Fox and apply it directly to the language of the Administrative Review Act here today. The agencies proffer that simply because there's a requirement that these SODs be posted mean that there's no reputational injury to my client does not make logical sense to me, and appears to be inconsistent again with the finding in Fox. In Fox, the court didn't even determine that there was reputational injury. The language in Fox says the challenge orders could have an adverse impact on Fox's reputation. So there wasn't even a finding. It's just that clearly, if the government says that you violated the law, and in this particular case, under these circumstances, where a resident has passed away, and effectively the government is trying to put some of that blame on my client, despite overwhelming evidence provided to the government that another party, perhaps two parties, were clearly responsible for it. This poor woman was given 3 anticoagulants, and the nursing agency that was ordered by the physician to monitor her intake and her dosages went back and fabricated the medical record to say that she had told my client 5 days before the resident passed away that a change in the medication had been ordered by the physician, when that clearly wasn't the case. This woman passed away as a result of taking these 3 anticoagulants. My client was able to get clear evidence from the treating physician that it wasn't my client's fault. Clear evidence that this other agency, this nursing agency, had clearly been responsible for this woman's death. Yet, despite all that overwhelming evidence, it was never considered. So on the website, on the state's website, it appears as though my client is responsible. And even though the court is correct that a correction of deficiencies might also show on that website, it's not as if it removes the initial information that creates the stigma. The government's argument that there is only a right to an administrative hearing when an order has been issued was rejected by this court in Bolser. The exact same argument was raised. The registrar of contractors stated that there could be no right to administrative review because no order had been issued, no administrative hearing judge had ruled on the matter. And this court said, no, it does not matter what you call it. If it looks like a final agency decision, it smells like a final agency decision. It is a final agency decision. And in this case, there is a final agency decision. And as I may have stated before, we know that there's a final agency decision because my client has done absolutely nothing to correct anything, yet this agency has somehow determined that the matter is closed. So clearly, there is a final agency decision warranting administrative review. Thank you.
Counsel, thank you. Thank you for your briefs. Thank you for your presentation today. We appreciate it. You've given us much to think about. We will take the matter under advisement. We'll issue a ruling, written ruling in due course. We'll now take a short recess while the courtroom is set up for our next argument. Thank you.